New Mexico has a clearly defined lease termination framework that balances landlord and tenant interests with specific procedures that both parties need to follow. The governing law is the Uniform Owner-Resident Relations Act, New Mexico Statutes, Chapter 47, Article 8, and it uses some unique terminology that sets it apart from other states. In New Mexico, landlords are referred to as owners and tenants as residents. Let's start with no-cause termination. For month-to-month tenancies, New Mexico requires either party to provide at least 30 days written notice before the end of the rental period. The notice must be given at least 30 days before the next rent due date for the termination to take effect. So, if rent is due on the 1st of the month and you want the tenancy to end on the last day of March, you need to deliver notice at least 30 days before April 1st. For fixed-term leases, the lease expires at the end of the agreed term without additional notice required, unless the lease specifies otherwise. If the resident remains after the term expires and the owner accepts rent, the tenancy converts to a month-to-month arrangement on the same terms. As always, if you don't want this conversion to happen, communicate in writing before the lease expires. For week-to-week tenancies, New Mexico requires 7 days' notice from either party, and the notice must expire at the end of a weekly rental period. Now let's cover termination for cause. For non-payment of rent, New Mexico requires the owner to provide a 3-day notice to pay or vacate. Under Section 47-8-33, the owner must deliver written notice giving the resident 3 days to pay the full amount of rent owed. If the resident pays within those 3 days, the notice is void and the tenancy continues. If the resident doesn't pay, the owner can proceed with filing for eviction in the appropriate court. New Mexico's 3-day non-payment window is one of the shortest in the country and gives landlords the ability to act very quickly when rent goes unpaid. The notice must clearly identify the amount owed and should be delivered in a manner that can be documented. For lease violations other than non-payment, New Mexico uses a 7-day notice to cure framework. Under Section 47-8-33, the owner must provide written notice specifying the violation and giving the resident 7 days to correct it. If the resident cures the violation within 7 days, the notice is void. If the resident doesn't cure, the owner can proceed with termination and file for eviction. 7 days is a shorter cure period than many states provide, which benefits landlords who need to address violations quickly. But the notice must be specific. It needs to clearly identify what the violation is and what the resident needs to do to fix it. Vague or overly broad notices can be challenged in court. For repeated violations of the same type, New Mexico has an important provision. If the same violation occurs within 6 months of a prior 7-day notice, the owner can terminate the rental agreement with a 7-day notice without offering another opportunity to cure. This escalation mechanism prevents residents from repeatedly committing and curing the same violation. For serious violations, including criminal activity on the premises, drug-related offenses, and conduct that poses an immediate threat to health or safety, New Mexico allows the owner to issue a 3-day notice to vacate without an opportunity to cure. This is the fastest termination pathway for lease violations in New Mexico and is reserved for situations where waiting for a cure period would be unreasonable. New Mexico's statute specifically addresses drug-related criminal activity as grounds for expedited termination. If a resident or someone under the resident's control is involved in the manufacture, distribution, or possession with intent to distribute controlled substances on the premises, the owner can terminate immediately and pursue eviction. Courts in New Mexico take drug activity on rental premises seriously and typically move these cases through the system quickly. One aspect of New Mexico law that owners should understand is the state's approach to domestic violence situations on rental property. New Mexico prohibits landlords from evicting a tenant solely because they are a victim of domestic violence. If domestic violence occurs on the property, the owner can pursue eviction against the perpetrator but not against the victim. This distinction is important and is codified in the statute to protect victims from losing their housing because of someone else's criminal conduct. The eviction process in New Mexico goes through the Metropolitan Court in Bernalillo County or the Magistrate Court in other counties. The owner files a complaint for restitution, and the court issues a summons to the resident. The hearing is typically scheduled within 7 to 10 days of filing, making New Mexico's initial court timeline relatively fast. If the court rules in the owner's favor, a writ of restitution is issued, and the sheriff carries out the eviction. The overall timeline from filing to physical removal is typically 3 to 5 weeks for uncontested cases. If the resident contests the eviction and raises defenses, the process can take longer, but New Mexico courts generally keep these cases moving. New Mexico also allows the owner to recover damages in the same action. This means that, in addition to getting possession of the property, the owner can seek a judgment for unpaid rent, damages to the property, and other costs, all in one proceeding. This streamlined approach saves time and legal fees. On the resident's side, New Mexico provides several grounds for early termination. If the owner fails to maintain the property in habitable condition, as we covered in our New Mexico habitability video, the resident can provide written notice and allow the owner 7 days to make the repair. If the owner doesn't act, the resident can pursue remedies including lease termination. For essential services failures, like no heat, no water, or no electricity, the timeline is even shorter, and the resident can take more immediate action, including procuring substitute housing at the owner's expense. Active duty military members are protected by the Service Members Civil Relief Act and can terminate with 30 days' notice following deployment or permanent change of station orders. New Mexico has several military installations, including Kirtland Air Force Base, White Sands Missile Range, and Holloman Air Force Base, so this provision affects a meaningful number of residents in the state. New Mexico provides early termination rights for victims of domestic abuse under the Abuse and Neglect Act and related provisions. A resident who is a victim of domestic abuse can terminate the lease by providing written notice, along with documentation such as a valid order of protection, a police report, or a statement from a qualified professional. The resident must provide at least 30 days' notice, and the owner cannot charge early termination fees or report the early termination as negative rental history. New Mexico strictly prohibits self-help evictions. Under Section 47-8-36, owners cannot change locks, shut off utilities, remove doors or windows, remove the resident's belongings, or take any action to force a resident out without going through the court process. The penalties are significant. The resident can recover up to 2 months' rent or twice actual damages, whichever is greater, plus attorney's fees. This penalty structure makes self-help eviction not only illegal, but financially devastating. One practical consideration for New Mexico owners: the state's diverse geography creates different rental market dynamics across the state. Albuquerque has the state's largest and most active rental market, and the Metropolitan Court there handles a high volume of landlord-tenant cases. Santa Fe has a tighter market with higher rents, and Las Cruces, near the Mexican border and White Sands, has its own dynamics, driven partly by military and university populations. Understanding the local market conditions can help you anticipate how termination situations are likely to play out. New Mexico also has specific rules about how personal property left behind by a former resident must be handled. After an eviction or voluntary move-out, the owner must store the resident's abandoned belongings for a reasonable period and provide notice before disposing of them. The specific procedures are outlined in the statute, and failure to follow them can result in liability for the value of the disposed property. New Mexico requires owners to return the security deposit within 30 days of the resident v.